This section relates to the FBI. It's a weird place to hide the power to appoint a special counsel to prosecute a former president anywhere, anytime. This section applies to the FBI's people, not Jack Smith. Jack is a group of lawyers, not a group of prosecutors. No binding or persuasive authority supports his position either, and this is all dicta. We're not in the Fannie Willis case. This is the classified documents case. Jack Smith on his heels again. Trump's defense team submitting their brief in the 11th Circuit. As we know, Jack Smith is trying to resurrect the classified documents case that was dismissed by Judge Cannon because Jack Smith is not a real boy, not a real prosecutor, was unlawfully appointed, and never should have been allowed to bring these cases in the first place. He's also misappropriated $36 million stolen, give or take, and the numbers are only going up. So here, Trump's team is telling the 11th Circuit, Jack Smith should not even be here, all right? It's already been dismissed. It is from President Donald J. Trump, brought by his attorneys Emile Beauvais and Christopher Keese, two attorneys extraordinaire, sending this in to the 11th Circuit. In the 11th Circuit, Trump's defense tells the Court of Appeals, all right, judges, there is not and never has been a basis for Jack Smith's unlawful crusade against President Trump. For almost 2 years, Jack Smith has operated unlawfully, backed by a largely unscrutinized blank check drawn on taxpayer dollars. More than $36 million has been spent unjustly targeting President Trump, and Trump through unprecedented encroachments on executive power, with Biden wrongly and inappropriately urging everybody to lock him up. Trump only days before the filing of this brief as part of their election interference strategy. Man, that was a hell of a sentence right there. Now, in the most thorough judicial treatment of these issues that exists, we're talking about Jack Smith being disqualified, the district court explained why Jack Smith and his actions violated our Constitution, namely the Appointments and the Appropriations Clause, and dismissed the case. At least one Supreme Court justice in the United States Supreme Court, two former attorneys general, Ed Meese and his friend, who administered the laws at issue, and several prominent legal scholars, like Watching the Watchers in our amazing chat, among others, support the same correct conclusions. Quoting a case called Morrison versus Olson, they say frequently an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of this asserted principle to affect important change in the equilibrium of power is not immediately evident and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf. Don't need to question it. Smith's unlawful appointment and conduct perpetuate all the evils that Justice Scalia's prophetic Morrison dissent predicted. And like presidential immunity, this appeal concerns issues that present risks to the institution of the presidency and will have enduring consequences on the balanced power structure of our republic. Now, while presenting little more than a regurgitation of arguments that the district court thoughtfully rejected, the brief of the special counsel's office offers casual and dismissive treatment of the serious separation of powers problems arising from Smith's unlawful appointment and funding. And they do so notwithstanding Judge Clarence Thomas, his explicit concerns. He wrote about this, that the appointment, he said, we must respect our Constitution's separation of powers in all forms, else we risk rendering its protection of liberty a parchment guarantee. In order to prevent that danger from coming to fruition, this court should affirm the 11th Circuit. The Appointments Clause and Jack Smith requires that officers are appointed by law. No law supports Smith's appointment. That's why their brief starts by emphasizing one single sentence from Nixon that cannot even qualify as anything but unreasoned, unpersuasive dictum. Moreover, even if Jack Smith is a valid officer, which he's not, he is a principal officer, not an inferior officer, in light of his lack of supervision and nearly unlimited jurisdiction and tenure to do whatever he wants. But he has not received the required presidential appointment, followed by advice and consent of the Senate. And finally, the terms of the permanent indefinite appropriation do not apply. So Smith's expenditure of tens of millions of dollars of public funds is also unconstitutional, and we need a refund. This court should affirm. So here's the statement of the case. They tell us, on November 18, 2022, just 3 days after Trump announced his candidacy, Merrick Garland from the DOJ came out, and he purported, didn't actually do it, to appoint Jack Smith as a special counsel to, quote, prosecute federal crimes. In the appointment order, he cited these different statutes and said that Smith is subject to the Code of Federal Regulations. Now, according to publicly available statements of expenses, Smith's, quote, office has spent $20 million here and another $16 million here. They've not disclosed any of their expenses for the last 7 months. I'm sure the number is in the many millions. It's election season after all. He's got a lot of appendices to drop on Chutkin's doorstep. Now, the district court's dismissal, they say, after approximately a year, we're in Judge Cannon's case, the classified documents case, after a year of litigation over their discovery failures and their unprecedented disregard of the Presidential Records Act and their related motion practice over Jack Smith's constitutional violations, the district court held that Jack's prosecution of this action breaches two structural cornerstones of our constitutional scheme. Judge Cannon said violation of the Appointments Clause and the Appropriations Clause. The district court then, Cannon, concluded that none of the statutes that they cited gave him legal authority for his appointment, nor do the statutory arguments or their inconsistent history of the application of those statutes or the reliance on out-of-circuit authority does it convince Cannon otherwise. Now, separately, the court identified compelling reasons to conclude that Smith is a principal officer, which would also violate the Appointments Clause without question. He's basically a one-man department. As to the Appropriations Clause, Trump's defense says the district court held that Jack's investigation has unlawfully drawn funds from the indefinite appropriations slush fund that the DOJ set up. So Trump's defense continues. In the 11th Circuit, their argument begins. All right, Your Honor, Jack Smith was not appointed by law. All right, there is no law. A grant of inferior officer appointment authority requires explicit authorization and permission from Congress. Nothing short of that will suffice. Congress has satisfied these requirements by explicitly providing for this under the rules. And these are the rules. This is how they appoint people. However, none of those provisions that we just cited authorize Merrick to appoint a private citizen named Jack as special counsel to target Trump by using power that exceeds the authority of U.S. attorneys who are, in fact, presidentially appointed and Senate confirmed. Everybody else has to go through those checks and balances in order to be a U.S. attorney and prosecute someone. Not Jack Smith. They just brought him over from Europe. The statutes cited in the order, Merrick Garland came out. This is why I have power, invoking this law and this law and this law. None of them pass muster. They are of a general nature, said Supreme Court Judge Justice Thomas. They're generic. They refer to attorneys from offices created by some other law. This section relates to the FBI. It's a weird place to hide the power to appoint a special counsel to prosecute a former president anywhere, anytime. None of those statutes gives Merrick any independent source to appoint him, and none at all. Now, the enactment histories of these and other provisions confirms the district court's conclusions. History lesson. Dating back to the Civil War, attorney general appointments outside of counsel focused on providing assistance to local federal prosecutors. Now, today, that authority is set forth in a statute, which they're relying on. There are several instances where Congress expressly provided for special counsel type appointments. In fact, in 1924, during a period that Jack Smith falsely mischaracterizes as involving widespread appointment practices consistent with the current appointment order, Congress passed a very specific law calling for the appointment of a special counsel to investigate the Teapot Dome scandal. Jack confines that episode to a single footnote. In 1978, Congress passed the Independent Counsel Act, which led to the authorized appointment of a special counsel, but that expired in 99. Now, to the extent that Jack has identified exceptions, they are outliers. Watergate investigations are one example, but heavy congressional involvement in those appointments, which did not occur here, mitigated separation of powers concerns. Watergate spawned United States versus Nixon, where the Supreme Court assumed in a single sentence, without any analysis, uncontested issue, which mischaracterized the statutes actually cited in the relevant appointment order, that the same provisions the AG cited to appoint Smith were adequate for the task. Wrong. The Nixon dictum is unpersuasive and it's non-binding, as are the out-of-circuit cases that applied it. And so Congress cannot acquiesce to Appointments Clause violations. Constitution doesn't allow it, but Congress did not acquiesce. They focused on a different issue. In fact, beginning with Watergate and for more than 20 years, Congress prioritized independence of special counsel from the executive branch. That's why they created it. That priority, along with the explicit appointment mechanism provided for the Independent Counsel Act, diminished the focus on other statutory authority for inferior officer appointments. Now, although no explanation is necessary, this contextualizes Congress's failure to expend political capital on potentially unpopular actions to rein in its criminal investigations in the manner accomplished by the district court's absolutely correct decision. The dismissal from Cannon should also be affirmed on the basis that Jack's role violates the Appointments Clause because he operates as a principal officer without presidential nomination or Senate confirmation. Smith has operated without the type of oversight and accountability that are the hallmarks of inferior officers. He's basically a one-man show, unless and until removed. The duration of his tenure, up to him. His expansive jurisdiction is bigger than U.S. attorneys. They're principal officers, and he has more power than them. He can operate in multiple districts. He can actually use them as force multipliers by making referrals to them. And finally, Smith also violated violated the Appropriations Clause. In addition to relying on 16 million stolen American taxpayer dollars, he's also stolen another 20 more from a 1987 slush fund they set up for the Independent Council. He meets neither requirement to get that money. The appropriation also requires that Smith actually be independent in the particular rigorous sense that attorneys that were appointed under the Independent Counsel Act, which is now expired, was creating safeguards to make sure they are more independent. He fails that standard too, and so he's not even meeting the standards necessary to get the money under the old standards, which are now void. Smith was not appointed by law. Okay, there is no law. It's undisputed that we need a statute from Congress. Other recent decisions establish that. We need a clear statement from Congress will suffice, and there is no clear statement. None of the statutes cited by Merrick Garland or Jack Smith appears to create an office for the special counsel, and especially not with the clarity typical of past statutes used for that purpose. Justice Clarence Thomas, in a concurring opinion in the Trump immunity decision. Clear statement rules apply when it implicates constitutionally grounded norms that we would not expect Congress to unsettle lightly, right? Congress is going to change something pretty important. They got to say so. The appointment order here was no everyday exercise of federal power. A private citizen cannot criminally prosecute anyone, let alone a former president, unless they're duly authorized to do so by the American people. How do we do that? We elect someone. That person then appoints someone, and then that person is confirmed by the Senate. The AG named a private citizen to target a former president and the leading candidate based on official acts pursuant to using his exclusive executive power at a time when that former president was campaigning to take the White House back from Biden's boss, Merrick Garland's boss. Therefore, there is no clear statement from Congress, and we need one. Jack doesn't have it. Congress has also provided for many other appointments, but not Jack Smith's. Their effort to concoct a statutory basis for Smith's appointment contrasts with other statutes. Many other statutes do appoint people. Several provisions track the principal officer language. Congress has repeatedly demonstrated that there are certain appointment powers, but they don't rely on any of those explicit provisions. Instead, they rely on the separation of powers. They ask the court to authorize something the statutes don't say. This section did not authorize his appointment, and they go through a lot of history here. Section 515 is not an independent source for the power. All this did was create territorial flexibility. It provides that the AG and two other categories of attorneys with authority to conduct proceedings. That's it. You don't get to appoint and create new offices. And any predecessors also didn't establish appointment authority. In 1903, a federal district court held that the revised statutes did not authorize an attorney to participate in grand jury proceedings. Similar to the reasoning here, the court pointed to the provisions that specifically authorize the appointment of officers. And an old case is mirroring this case. And so Congress passed a law that mirrors that. A lot of history here. Same thing with Section B. There is no textual basis for the claim that retained is synonymous with appointed. The only authority they say is from 1883, where they're talking about appoint and employ. Doesn't really matter. It's kind of the same thing. But this section doesn't create the power to issue a commission, much less an appointment, so it doesn't include it in there either. That argument does not establish the authority to undercut Cannon's reasoning. They say 515, you cannot say Jack Smith is legitimate because he's a special attorney. The term special attorney is referencing special attorneys, only for specific purposes. And they say Jack Smith is not that, because it's not a special purpose. He was not appointed to assist a U.S. attorney. They talked about that, so he's much broader. That power, special attorney power, goes back to 1861. It's somebody who is assisting the district attorney. It was transferred to the revised statutes later. Over time, Congress provided for other types of specially designated attorneys, but it's not an appointment power. It's to go hire and work with other attorneys to work with you. Similarly, it goes on. Other cases are showing that the language matches their interpretation, not Jack Smith's. Section 17, the predecessor, even going back before the current version, right? Where did this come from? The Senate report also demonstrates that Congress was attentive to the Appointments Clause and did not view the paragraph as creating the appointment power. Similarly here, this section applies to the FBI's people, not Jack Smith. Jack is a group of lawyers, not a group of prosecutors, so that does not cover him. His power should be in the DOJ provision, not in the FBI provision. Now, in response, Jack Smith's office largely regurgitates the inopposite statutory citations that we've already distinguished here. The context of this says it's not valid. It's for the FBI. It's not for him. They wouldn't tuck in special counsel in the middle of the FBI when there's a whole DOJ section. Justice Thomas observed, this would be a very curious place for Congress to hide the creation of an office for a special counsel tucked away in Christopher Wray's pockets. All of the numbered paragraphs are also saying this is FBI stuff. This is a curious place to shove that in there so he doesn't have the power. In 1909, in 1933, in 1935, it goes on. And then and they created Section 533 eventually. And the Justice Manual says it's for the FBI as well. So 533 is not for the special counsel, it's for the FBI. 509 and 510 also didn't support Jack's claim. These are generic provisions. This is the function of existing DOJ officers and agencies. 510 authorized the delegation of any functions to existing other officers. So yeah, you can delegate powers and duties. You can delegate them to officers, but the delegation power does not equate to the appointment power. The new argument relies on a series of inferential leaps with no legal basis. Surprise. The AG was not free to hire Smith as a non-officer employee and then elevate him to this. You can't hire him to like get your coffee and then all of a sudden, oh, well, you're promoted now, and say that doesn't violate the clause. There would be no need for that language if they could just do that and make an end run around the appointments clause. So the historical discussion that they brought up again is inaccurate. Truman's reorganization plan for the DOJ is missing key aspects of that process. Truman's message was that the DOJ plan lacked any suggestion about broad new powers. If Johnson had those powers, someone forgot to tell him he sought approval for new boards. He sought congressional approval for the establishment within the DOJ of new people, new officers. He wouldn't need to request that if he had the power already in his agency, in his executive branch. So nobody else has exercised power this way, obviously, except Jack. Now, their remaining historical arguments fail. His selective history of prior special counsels does not confirm the legality of his appointment. Yeah, there's a turbulent history of here because there's a bunch of different laws. Over time, political pressures produced special prosecutors. Teapot Dome scandal, 1924. There was advice and consent under the Appointments Clause. Justice Thomas pointed out that the Independent Counsel Act is another example where Congress expressly provided for a special counsel. They said, yeah, like here's an act, here's a new position. So why didn't they do that for Jack? Consequently, as discussed in more detail, the historical record is insufficient to warrant that they can utilize this power. They've got a whole series of cases that came before Watergate. The pre-Watergate cases have had a lot of developments. They cite congressional debates. They talk about the Truman administration, Watergate, where they were talking about securing independence of attorneys. Archibald Cox comes in here. A lot of detail in this brief. No binding or persuasive authority supports his position either, and this is all dicta. We're not in the Fannie Willis case. This is the classified documents case. Special counsel says that it was critical to their holding. The Nixon case, Trump's people say it was dicta. I hardly knew him. Nixon contains only a passing reference that is even arguably relevant to this case. There is no validity of the statutory authorization of the regulation appointing Cox. In Rudolph, another case, and another case, and another case. So they're saying you have to follow Nixon. They demand blind adherence to this. It's an unreasoned statement that's not even applicable here. The dictum appears to have been lifted nearly verbatim from a conclusory assertion from Jaworski's brief, which they didn't even talk about. And so the district court was well aware this is dicta, and there is Supreme Court dicta. And so any opinions that are based on Nixon are also not persuasive because Nixon is bad. Now, for all the reasons, you should find that Judge Cannon was correct. Jack Smith is not appointed by law. And if he's not appointed by law, everything he's doing is unlawful. Therefore, dismissal was also appropriate. Smith is not subject to any oversight. His jurisdiction is too broad. He's not an inferior officer. The district court discussed these at length and found them to be compelling. First, he has the full power and independent authority to do whatever he wants as a U.S. attorney. Those are all principal officers. He's not. Regulations also say that they can remove people in the DOJ, but he will not be subject to the standard oversight, and that coordination with the Biden administration is, quote, non-existent. Similarly, he has more protection against removal than other people, and there are no meaningful limitations on his tenure. And so for all these reasons, he is clearly a principal officer, and he's stolen funds. He's been relying on a blank check from an indefinite appropriation slush fund. They require that money to be used for the designated purposes, and those designated purposes were for independent counsels. He's not that. He spent $16 million here, $20 million here, and the district court expressed concerns about the appropriation, saying that money was for independent prosecutors. He is not completely independent of the DOJ. The restrictions are not consistent with the standard that money was for. That's why there is tension between his office and the money. His lack of sufficient independence for the money, which required independence, is a problem. The Government Accountability Office found Fitzgerald to possess the level of independence necessary because he had no supervision or control of anybody in the department, but that is not Smith's case here. And so all of his money is now stolen, and so therefore the court should dismiss the case. Signed by Trump's defense team, Todd Blanche, Emil Bove, Christopher Keese, going up at the Court of Appeals in the 11th Circuit. They say this court should affirm. Make Jack Smith go away. He was not lawfully appointed. We'll be here continuing to cover it. Thanks for subscribing, my friends, if you haven't already, and we'll look forward to seeing you back back here on the next one.